There's a story unfolding right now in the world of gun rights that is so unbelievable, so backwards, and so potentially dangerous for the future of the Second Amendment that I honestly think most gun owners still don't understand how big it is. Imagine waking up and finding out that a federal judge has ruled that suppressors, something millions of responsible gun owners use for safety, hearing protection, and responsible shooting, are not protected by the Second Amendment. Not because they're dangerous. Not because they're illegal under federal law. Not because criminals are misusing them. But because, and I'm not joking here, they apparently did not exist in 1791. Yes. A modern judge has decided that your rights today depend on what technology existed when people were shooting flintlock muskets. And if this logic stands, it won't just stop at suppressors. This could open the door to stripping constitutional protection from red dots, optics, detachable magazines, polymer frames, modern rifles, and almost every innovation that gun owners rely on today. What's happening is not just a legal case. It is a direct attack on the modern interpretation of the Second Amendment. And the craziest part, the story is only beginning because this case was thrown out by one judge but is now on appeal, climbing toward a court that may redefine gun rights for the entire country. Let's start at the beginning. Two major lawsuits were filed to challenge Illinois' complete ban on the purchase and possession of suppressors. The cases, Morris v. Raoul and Anderson v. Raoul, were consolidated because they deal with the exact same question. Can a state outright ban suppressors when the Second Amendment protects arms? You might think this is a simple question. After all, the Supreme Court has already ruled that states cannot ban entire categories of arms that are in common use for lawful purposes. Suppressors are legal in 41 states. Millions of Americans own them. So naturally, you would assume that courts would at least consider whether suppressors fall under the umbrella of arms. But instead of doing that, the lower court in Illinois dismissed the entire case. Here's where it starts getting shocking. The court ruled that suppressors are not protected under the Second Amendment because there is no history or tradition showing they were considered arms at the time of the founding. Think about that. The judge is not saying suppressors are dangerous. The judge is not saying suppressors are uncommon. The judge is not saying suppressors serve criminal purposes. The judge's entire logic comes down to one sentence. Suppressors didn't exist in 1791, so they're not protected. This flips the entire foundation of modern constitutional interpretation upside down. Imagine applying this logic to the First Amendment. There were no televisions, no radios, no internet, no smartphones, no satellites, no podcasts, no cameras, no microphones, no digital printing presses in 1791. So should all modern communication be unprotected? Or imagine applying it to the Fourth Amendment. There were no electric safes, no laptops, no cell phones, no encrypted drives, no smart homes, no cloud data storage, no GPS trackers, no digital records. Should police be able to search those without warrants because the technology didn't exist? Of course not. Rights don't shrink because technology evolves. But somehow this judge believes that only the Second Amendment is frozen in time. The plaintiffs argued exactly that. They explained that the Second Amendment, like every other amendment in the Bill of Rights, adapts to modern reality. The First Amendment covers modern communication. The Fourth Amendment covers modern forms of search and seizure. The Second Amendment therefore must cover modern tools that assist with armed self-defense. Suppressors reduce sound, protect hearing, control recoil, and improve safety. They attach to firearms used for lawful protection. Millions of Americans use them. They clearly facilitate armed self-defense. But even with all of that, the judge said no, because plaintiffs cannot point to a colonial-era device designed to reduce the report of a musket. In the judge's own words, suppressors are accessories, not arms themselves. He then went even further, creating a test that the Supreme Court never established. The judge claimed that a modern firearm component is only protected if there was a historical analog from 1791. That is not told citizens they had to prove that suppressors were historically recognized. He told the state they did not need to justify the ban at all. And this is why so many gun rights attorneys are sounding the alarm. Because if courts start placing the burden on citizens to prove the Constitution protects their rights, then the Constitution becomes meaningless. Now here's where the story expands beyond suppressors. Anti-gun states like New York, New Jersey, and California are already preparing to use this ruling to defend their own bans. If suppressors aren't protected because they didn't exist in 1791, then neither did red dot sights, modern optics, polymer frames, laser sights, semi-automatic firearms, detachable magazines, night vision attachments, pistol braces, binary triggers, and arguably even AR-15s. Think about that for a moment. Through one ruling, a judge has handed anti-gun states a template to argue that anything created after 1791 is not protected. This is why gun owners are calling this ruling a nightmare scenario. Because the Second Amendment protects the right to keep and bear arms, not outdated, obsolete, historical replicas of arms. The founders wrote broad rights for a reason. They knew the world would change. They knew technology would evolve. Rights must evolve with them. Otherwise, the Constitution becomes nothing more than a museum relic. After the ruling, plaintiffs appealed immediately to the Seventh Circuit Court of Appeals. This appeal is absolutely massive. It will force a panel of federal judges to decide whether the lower court misunderstood Bruen or whether suppressors truly have no constitutional protection. Plaintiffs are arguing that Bruen clearly places the burden of proof on the government, not the citizen. They also argue that the lower court's test, requiring an 18th century analog, is unconstitutional and goes against the Supreme Court's modern direction. They point out that suppressors are attached to firearms commonly used for lawful defense, and therefore they must be protected. They argue that accessories integral to the safe and effective operation of a firearm cannot be banned simply because the technology is new. These are powerful arguments. And depending on how the Seventh Circuit interprets Bruen, we could either see the lower court reversed, or we could see a new wave of anti-gun rulings nationwide. That brings us to the bigger picture. If the Seventh Circuit agrees with the lower court, anti-gun states will immediately take advantage. New York will say suppressors are unprotected. New Jersey will do the same. California will cite the case in every lawsuit they face. Hawaii, Delaware, Rhode Island, all the usual states will follow. It won't stop there. States will start claiming there is no historical analog for detachable magazines, or pistol optics, or high-capacity magazines, or semi-automatics, or night vision, or barrel shrouds, or adjustable stocks. The argument will be simple. Show us the 1791 equivalent. And when you can't, they'll say, then it isn't protected. And that is when the Second Amendment stops being a living right and becomes a historical artifact. This case is not just about suppressors. It's about the future of every modern tool associated with lawful firearm ownership. We are at a moment where appellate courts must decide whether they will follow the Supreme Court's clear instruction in Bruen or carve out exceptions that allow states to target modern firearms technology. And make no mistake, the Supreme Court is watching. The justices have already shown that they will strike down laws that contradict Bruen. But before this case reaches the Supreme Court, it must go through the Seventh Circuit, and that decision will shape the next steps of the entire legal battle. The ripple effects are everywhere. Gun owners in the 9 states that still ban suppressors were hoping this lawsuit would finally force their states to recognize suppressors as protected arms. Instead, the opposite has happened. A judge has given those states ammunition to defend their bans. And as the appeal moves forward, thousands of gun owners are waiting to see whether the higher court will restore the correct test or uphold this new and dangerous interpretation. The plaintiffs are pushing hard, arguing the technology does not limit rights, and that accessories attached to common-use firearms must be protected. Anti-gun states are pushing the opposite narrative, hoping that the Seventh Circuit will affirm a narrow reading of the Second Amendment that locks gun rights in the 18th century. This case is now one of the most important Second Amendment cases in the country. It is bigger than many magazine ban cases, bigger than some AR-15 cases, bigger than pistol brace litigation. Because it strikes at the core question, does the Second Amendment protect modern firearms and modern accessories, or only the technology that existed in the 1700s? If the courts choose the latter, then the right to keep and bear arms will slowly shrink with every new technological advancement. If they choose the former, then modern gun ownership will continue to be protected as the founders intended. As we move into the next phase of this legal battle, gun owners must stay informed. The filings in the Seventh Circuit, the oral arguments, the amicus briefs from gun rights groups, and a potential move toward the Supreme Court will all shape the path forward. This case has implications that stretch far beyond Illinois. This case affects the entire country, every gun owner, every state, and every modern component that people rely on for defense, sport, competition, and safety. The fight is not over, not even close. And as soon as the Seventh Circuit releases its opinion, The conversation will shift from one courtroom to the entire nation. Stay alert, stay aware, and stay prepared, because this case may determine the future of your rights.